Welcome to our last video on the Bill of Rights, where we cover the 8th, Ninth, and 10th Amendments. Three of the shorter amendments, so we should be able to make good time here. But before we get started, let's just quickly recap where we've been so far and what we've covered. We began by looking at the First Amendment, the four freedoms: freedom of speech, freedom of religion, freedom of the press, and freedom of assembly. We then looked at the Second Amendment, the right to bear arms. The Third Amendment, no quartering of troops in citizens' homes. We spent quite a bit of time talking about the Fourth Amendment, your right to privacy involving search warrants. And of course, the Fifth and Sixth Amendments, the rights of the accused. Spent almost an entire video talking about those two amendments. And then finally, the Seventh Amendment, which is really just an extension of the rights of the accused. It applies jury trials to civil cases. So next, let's look at the Eighth Amendment. A pretty short one. Look at this. It's one sentence. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Is that a sentence? I don't know if it's grammatically correct, but there it is, the Eighth Amendment. And the key word here is excessive, too much of something. So we don't want to give the government too much power. Of course, that's a big part of the Constitution. How do we limit the government's power, but still give them enough power to get stuff done? In this case, we want to limit the power of the government to enact severe punishments on us when it's time for them to, deal down a punishment for a crime. So let's break this down a little further. Really, the Eighth Amendment is talking about two things: bail and then your punishments. So let's explain bail a little bit. Bail is the money that you give as a guarantee that you're going to show back up for a trial. So if you're put under arrest, chances are your trial is not going to take place for weeks and weeks and weeks. First they have to have a grand jury look at the evidence. We saw that in the Fifth Amendment, and decide if there's even enough evidence to put you on trial. And once the grand jury comes back with, let's say they do decide to indict you, which means to officially charge you with a crime, they vote yes, there's enough evidence. Well, then they got to schedule the trial, and they got to pick jurors and a judge. And literally that could take months. So the idea with bail is it's not fair to let a person sit in jail, and even though they may be innocent, right? Because until you're found guilty at trial, you're assumed to be innocent. So we're not going to let people just sit in jail waiting for a trial, because you could end up going to jail for 2 or 3 months just waiting for the trial for something you didn't do. So bail gives people an opportunity to get out of jail until their trial. So let's just break this right down. You commit a crime. The police gather some evidence. They think you did it. They come to your house. They arrest you. What happens next? They take you to jail. They photograph you. They fingerprint you. And then you sit in jail until you have a bail hearing. A bail hearing is where you go before a judge. The police say, look, this is what we think you did. And the judge looks at you, might ask you a couple questions, and then he says, okay, we will let you go if you put up bail. Now, what does that mean? Well, let's say in this case that your crime was like you robbed a bank, so it was a pretty big crime. The judge is going to probably impose a high bail. He's going to say $100,000 bail. What does that mean? It means that if you can come up with $100,000 and give it to the court, they will let you go until it's time for your trial. They will give you your money back if you show up for your trial. So the bail money is there to guarantee that you're going to show up. If you don't show up, they keep the money. Now, most people don't have, say, $100,000 lying around. So this is where bail bondsmen and bounty hunters come into play, because what you would probably do is go to a bail bondsman. That's a business that they make their money by putting up bail for people who can't afford it. You might go to a bail bondsman and say, look, I got $5,000. That's all I have. But they say $100,000 bail. And of course, you're not going there. It's your lawyer, your family member doing it. And they would say, okay, we have $100,000 and we'll put the bail up for you. We'll give that money to the court. And in exchange, you're going to give us $5,000 and you don't get that money back. That's the price you're going to pay for us loaning you the $100,000 to get you temporarily out of jail until your trial. Well, if you don't show up for trial, they're going to be out $100,000. So that's where they're going to set the bounty hunter on you to track you down and drag you to jail so they can get their $100,000 back. Just wanted to explain that because I know some of you have heard of bounty hunters. So that's how bail works, but bail is starting to become a little bit of a thing of the past, at least in certain states, because recently, I believe it was 2019, in New York State, they passed a law to get rid of bail for most non-violent crimes, which means instead of being put in the back of a police car, handcuffed, and brought down to jail because you broke into somebody's house, they just give you a ticket. That's it. And say, please show up for court. Now, one of the reasons why this was passed is there were some people who are saying, look, there's certain groups of people, especially people who are poor, who are sitting in jail for months at a time, and they just can't afford the bail, and it's not fair to them. So I guess there's that side of it. But of course, there are other people who said, wait a minute, you're not even going to send people to jail? Like someone broke into my house and I'm going to watch the police just let them go and hope they show up for trial? As you can imagine, it was not a super popular law. And they recently backtracked on that a little bit. They passed another law that started to add back to the different list of crimes that bail is still allowed for. But it is the case in New York and other states that there are certain crimes that they will just trust you to come back to jail now, or come back to trial. Now, the serious crimes, of course, bail still applies, especially if it's a violent crime, they're going to put up bail. And if it's a really violent crime, you might not get bail at all. Your bail might be no bail because, of course, they're afraid that if you're let go, you might go hurt somebody else. You might not show up for the trial at all. You might leave the country, and then you'll never be punished for the crime. So that is how it works with bail. Now, the death penalty, this is a different topic. Is the death penalty considered to be cruel and unusual punishment? Now, this is one of those hot topics that people like to argue about. Is the death penalty cruel? Because that's the only guidance the Constitution gives us. No cruel or unusual punishments. So what's cruel? What's unusual? Dipping you headfirst into a vat of battery acid? How about the old way of doing things in England where they tied each arm and leg to a different horse and yelled, "Giddy up"? We can probably all agree that's cruel and unusual, but what about telling a person the exact day and time they will die, lock them in a cell to think about it, and then on that day strap them to a hospital table, stick a needle in their arm, and pump them full of poison? Some of you might say that's cruel, but if they murdered your entire family, maybe not. People debate this, and for good reason. And then there's the biggest problem with the death penalty. There's no taking it back. We found some new evidence. Someone else did it. Better let him go free. Whoops, we can't. We killed him last November. Get the idea? So who's going to decide this? Who's going to step in when we're trying to decide important constitutional issues? When we're trying to interpret the language of the Bill of Rights and what it means? Who decides if something is cruel and unusual? Yep, I was thinking the same thing. The Supreme Court, right? Except, as it turns out, the Supreme Court gets to decide what they decide. And in this case, the Supreme Court has refused to decide this issue. They have so far refused to make a ruling on the death penalty, which is the same thing as telling the state governments that they get to decide for themselves. And as it stands today, we've got 30 states that have the death penalty. 20 states have gotten rid of it, including New York. So in New York State, the maximum penalty that you can get for a crime is life in prison. And this is another example of federalism, where power is shared between state and national governments. And I know what you're thinking, Mr. West, you skipped an amendment. What happened to the Ninth? We'll come back to the Ninth Amendment in a minute, but I wanted to jump to the 10th because that's really what the 10th Amendment is all about. The 10th Amendment says that powers not delegated, not given to the United States government by the Constitution, are given to the state governments. So if the Constitution doesn't say something about a certain topic, I'll give you an example. Education, the Constitution doesn't say anything about the national government having the power over education. Then it becomes the power of the states to make those decisions for themselves. Now, is the death penalty really a federalism topic? Well, the Constitution doesn't say anything specifically about the death penalty. And that seems to be how the Supreme Court has interpreted it. They are not making a decision on the death penalty. And since the Constitution doesn't say anything specific about the death penalty, it just says no cruel or unusual punishments, then the people of each state and the governments in each state get to decide for themselves if that is a punishment that should fit any crime. Now, of course, this does not just apply to the death penalty, nor just to education. It applies to anything that the Constitution is silent about. And this is really a great amendment. If you think back to when the Constitution was first written, there were a lot of things that the founding fathers just could not anticipate ever happening. They had no idea that someday we would be flying on planes, that we would be using the internet. There's a whole bunch of things that are part of our society today that they just could not have anticipated or known that they were going to happen. So the Constitution is not super detailed because it couldn't be. They had no idea what the future would hold. But there is this amendment here that gives us some guidance on all those topics that the Constitution says nothing about. And the guidance is it becomes the states that decide and the people who live in those states. Now there's a catch here, and the catch is called the elastic clause, which is the last new thing that I'm going to tell you about the Constitution, because this is not in the amendments. This is in the Constitution itself. So the Constitution, it lists all of the things that Congress has control over and the power to do. But at the end of that list, it says, and Congress has the power to pass whatever laws are necessary and proper to help them carry out their powers. This is sometimes called the elastic clause, sometimes called the necessary and proper clause. It's like a rubber band. It allows the Constitution to stretch and be flexible to new situations that they just couldn't think of in 1787. So in my mind, at least, there's a bit of a tug of war going on between this elastic clause that gives the national government extra power and the 10th Amendment that gives the states any powers not listed in the Constitution. But in the end, it gives us a good balance, and that balance is called federalism. Now let's go back to the 9th Amendment to wrap things up. Maybe the smartest amendment of all. Remember when I called the amendments the whoops we forgots? Well, the 9th Amendment is the whoops, we might have forgot a bunch of other stuff too. The 9th Amendment says that just because the Constitution lists certain rights doesn't mean you don't have other rights. For example, the Constitution doesn't say you have the right to skateboard, but that doesn't mean you don't. The Constitution doesn't say search warrants apply to your email, but they do. So another great example of the Constitution being flexible and able to change with the times. So that's it. We're done. There's the Bill of Rights, the first 10 amendments to the Constitution. Please be sure to complete your quiz after you watch the video.